Hi, everyone. My name is Molly Hobbs. I am a partner in Husch Blackwell's Employee Benefits and Executive Compensation Group. Thank you for joining us today and welcome to our webinar. Before we get started, I need to cover a few housekeeping items. At the top of your audience console, there are multiple applications for your use during the program today. If you have any questions during the webcast, please submit via the questions box. We are going to try to answer these, but if a fuller answer is needed or we run out of time, we will answer them later via email. So go ahead and stick those in the box. A PDF of our slides is available in the program materials folder at the top of your screen. This program has been approved for legal education hours. For live attendees, report your hours by clicking Continuing Education sign-in link at the top of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of our program, be sure to complete our short survey. We use your feedback to plan for future programs that are applicable to your business needs. And that is all for housekeeping. So we are going to get started with our program. Joining me today is my partner, Craig Kovarik at Husch Blackwell. And I have to embarrass Craig for just a second here because I just found out today that Craig was named by the best lawyers in America as the Lawyer of the Year for Employee Benefits and ERISA law. So you all are in for a treat because he's kind of a big deal. Also joining us is our friend Jack Keller. Jack is a Senior Vice President and a retirement plan consultant at CBIZ. He specializes in the strategic management of retirement programs, specifically fiduciary governance, investment strategy, fee benchmarking, and making sure employees have the tools they need for financial well-being. All right, so on to the good stuff. I will apologize in advance because I got stuck with the boring stuff. So I am going to be tasked with talking to you all about the required and discretionary plan amendments. We're then going to jump into plan design considerations and best practices for fiduciaries. We are doing our absolute best to reserve about 10 minutes at the end of our presentation for questions. Once again, go ahead and stick those in the box. We are not able to hear you no matter how loud you scream at us. So, so drop those questions in and we will save those for the end. All right, so the first thing we're going to talk about is required legal updates and deadlines. Before we really get into the nitty gritty here, I thought I would take a step back and give a really the 10,000 foot view on all of this. So as tax sheltered annuity plans are not new. They've actually been around since the 1950s. However, they've been kind of an interesting world. They've been a little bit of the Wild West. We really only started seeing strict regulations of these plans in the past 20 years. Until about 2009, there wasn't actually a formal rule requiring a written plan document. So those folks who weren't subject to ERISA were actually getting away with just sponsoring a 403B plan in their heads, apparently. So, but at any rate, within about the past decade, 12 years here, the IRS started to, decided that they wanted these to be a little more regulated. So we started seeing some things that would bring these a little bit closer to our friends in the qualified or 401k, 401a plan world. So in 2013, the IRS opened its first 6-year remedial amendment cycle for reviewing and issuing opinion letters for 403b pre-approved documents. So for those of you who have been doing this for a while, you might remember doing your cycle 1 pre-approved plan document. Those would have been adopted and approved in, they had the kind of the drop dead date there was June 2020. Nothing else going on in the world then, so I'm sure you all distinctly remember adopting your 403b plan cycle 1 document. And we're doing this presentation today because we're now nearing the end of cycle 2. So what's been happening in the background here is that between May 2022 and May 2023, your service providers were submitting their documents to the IRS for approval. And then earlier this year in January 2025, those documents that were approved by the IRS The IRS said, yep, go ahead and send those out to your employers. So you've probably been hearing from, or you will be hearing from your service providers asking you to restate your pre-approved 403B plan documents. For those of you out here there that are thinking, I'm not on a pre-approved plan, why am I sitting here? We haven't forgotten about you. We do know that there are individually designed plan documents in this world. I guess just a quick aside. So an individually designed plan document is a plan document that's prepared by an attorney. They are not pre-approved by the IRS, and they're typically more complex. You are probably saying, well, this restatement window, I haven't heard anything about it, and you're correct. So the restatement window, a plan restatement window, does not apply to individually designed plans, but unfortunately you are not off the hook. So all 403B plans have to be amended to comply with major legislation enacted in the past 5-ish years. And stay tuned, please don't sign off quite yet, because the guidance that we're going to be talking about that has been issued for pre-approved plan documents provides a lot of insight into what the IRS is thinking, what they want, what they need. And as you all know, if the IRS is happy, we are all happy. So at any rate, jumping back into our pre-approved amendment cycles here. So we got back in 2022, the IRS issued what's called the cumulative list of amendments for their Cycle 2 restatements. They subsequently issued an updated listing of required modifications and information package, which we all call LRMs, because there's just not enough acronyms in this world. So we got all of those out in 2022, which informed what your service providers were doing with their plan documents that they subsequently submitted to the IRS. So when you are receiving documents from your service providers, you might be asking, well, what's living in this? What has changed? What were some of those required amendments? I'm going to jump through some of those. Once again, this is pretty technical and kind of a little sleepy, but hang in there. I promise we are getting to the good stuff. So what was living in those LRMs? There were some changes for safe harbor plans, permitted mid-year reductions or suspensions for safe harbor non-elective contributions in certain circumstances, and elimination of safe harbor notice requirements in certain circumstances. We also had some changes to hardship distribution rules. Specifically, the 403B plan is no longer able to provide for a 6-month suspension of elective deferrals as a condition of obtaining a hardship distribution, and your participant is no longer required to take any available loan under the plan to be prior to becoming eligible for a hardship. I'm jumping through these pretty fast so that we don't fall asleep. There's also some changes to the required minimum distribution rules, which is incorporating some of the recently proposed RMD regulations. I'm not going to go into detail on those. You'll have to contact us directly to get into the nitty-gritty on that. We can do a whole nother webinar, I'm sure. We also have some changes to spousal rights with respect to same-sex spouses in accordance with a U.S. Supreme Court decision, U.S. v. Windsor, which was actually a 2013 decision. So as you can tell, some of the stuff has taken a while based off of these remedial amendment cycles. It's just taken some time. So you're going to notice there might be some updated language in there to accommodate same-sex spouses. There are also some changes to some definitions. For example, qualified matching contributions will be updated. Qualified non-election contributions will also be updated. Each adopting employer has to indicate in the adoption agreement for non-discrimination purposes, whether it's a church plan, a governmental plan, a qualified church-controlled organization, or a non-qualified church-controlled organization, or a minister. Getting into, that's a nice segue. I wanted to give a quick shout out to those of you on today sponsoring church plans. So we do have some specific required legal updates for church plans. So employees of a QCCO and non-QCCOs are now expressly permitted to participate in 403B9 retirement income account plans. And those 403B9 plans can include ministers and chaplains. We also got some good rules and regulations surrounding plan mergers between church plans. Government plans, we have not forgotten about you. There just wasn't as much out there specific to you, but we did get some confirmation in the past few years that governmental entities and public schools can continue to use a reasonable good faith standard for determining whether or not whether they are in a controlled group. So exciting stuff there. Again, the deadline that you will have to restate your plan if you are on a pre-approved plan is December 31st, 2026. And for those of you with individually designed plans, once again, you may not be restating your plan, but if you've got any required amendments, those also will need to be made by the December 31st, 2026 deadline. So y'all now have a heads up, got over a year and a half, maybe a little less than a year and a half to get moving on this. All right, so discretionary amendments. So there's a whole other camp of stuff here that you aren't necessarily required to do to your plan, but you might be doing some updates to your plans. And this is kind of a, so if you had a cycle 1 restatement, once again, you were restating that in, you had to restate it by June 30th, 2020. And as some of you may remember, over the past 5 years, we've had some pretty significant legislation roll out. Specifically, in December 2019, we had Secure 1.0 come out. In March 2020, we had the CARES Act. That was the big COVID package. And then in December 2022, we got Secure 2.0. So in the past 5-ish years, we've had some massive pieces of legislation, which there was a lot of things living in there that you could adopt with respect to your with respect to your retirement plan. So at any rate, what some of these discretionary amendments and what we're getting at here is that you may have updated your plan for Secure 1.0, Secure 2.0 in the CARES Act. You may have adopted some of those optional provisions. But in the past 5 years, as typically happens when we are implementing, we get some really good legislation in there, and then we get guidance, and then we realize that the guidance is kind of not totally capturing everything we need to. So we get subsequent guidance. So for example, under Secure 2.0, a plan could allow Roth treatment for employer contributions or non-elective contributions. And last year, the IRS issued Notice 2024-2, which provides some additional guidance on this provision. So you might, if you had adopted that provision that existed in Secure 2.0, you might actually have some additional updating to do to your plan, which would be a discretionary amendment. Again, there was under the CARES Act, we had required minimum distributions could be waived for 2020. We've had some additional guidance from the IRS, notices 2023-54, 2024-35, provided some transition relief. So again, if you'd adopted some of these provisions that existed under these large pieces of legislation that we had come in the past 5 years, you might have some additional discretionary amendments that you'd be making to your plan at this time as well. All right, so I'm going to talk briefly on recent topics in fiduciary litigation. And these are kind of, I'm laying some groundwork because as we get into the kind of meat of our presentation here, these are just kind of some good reference points to be using as to why you might be making certain changes to your plan document or why you might be adopting certain practices as a fiduciary. So in the past 2 years, I think particularly our friends out there on the call today that are universities, I suspect you realize that over the past decade, you've been targets for some fee litigation cases. These claims, for better or for worse, have become fairly familiar. So you got too many investment options, you failed to replace expensive or underperforming investments, and you charged above market fees for investments or record-keeping services. Those have been the plaintiff's favorite claims to date. We've had a few more novel claims come in as well. So specifically to those 403B plans, we've got plans with multiple record keepers generating duplicative or excessive fees to plan participants. We've got a new class of lawsuits out there is saying that there's been a misuse of forfeiture assets, and also some alleging that there's an imprudent selection of target date funds. One case that I wanted to talk about because it hit the Supreme Court and came out earlier this year is that we had Cunningham versus Cornell. That is Cornell University. That was a case that was actually filed back in 2016, so it's almost a decade old at this point. It takes a long time to get up to the Supreme Court. But at any rate, the core of that case was that about 28,000 Cornell University employees accused the school's 403B plans of paying excessive record-keeping fees, in part by keeping too many investment options in the investment menu and by working with multiple record keepers. In April, this snuck up to the Supreme Court kind of on a technical pleading issue. And the result is an interesting one because it might actually, there's some speculation that it could open the floodgates to additional plaintiffs' claims, kind of yet to be seen. So essentially what that ruling coming out of the US Supreme Court, in case you were getting information hitting your inbox on the Cunningham case, is that essentially removed a potential procedural roadblock to the dismissal of weak claims in the pleading stage. So again, we're not going to get too big into this today because we could do a whole nother webinar on the Cunningham case and the procedural issues there. I think probably the biggest takeaway is that the Supreme Court didn't do plan sponsors many favors. It's pretty technical, but kind of yet to be seen what the fallout is from that one. I'll spend a second here talking about forfeiture litigation. So we've got a new wave of lawsuits challenging how forfeitures are used. The core there is that, as many of you may know, it's pretty common for your plan document to extend a lot of flexibility as to the use of your forfeiture accounts. So for example, the administrator could use the forfeitures to pay for benefits for the remaining participants rather than using those funds to defray administrative expenses. The claims that are coming out of that are that plan fiduciaries operate under a conflict of interest in administering their forfeitures, and that the plan fiduciary should be using forfeitures to pay for plan administrative expenses rather than to offset the employer contributions. We don't have a lot to update you there yet. Those are still trickling through the court system. The other note that I'll make here is on the on the target date funds. We've had some lawsuits challenging the selection of target date funds, essentially saying that those target date funds underperform compared to other available options. Lastly, I'll just note that there are, there's all sorts of fiduciary litigation out there with defined contribution plans. But 403B plans are kind of unique in that, a lot of times there is more than one record keeper, and that's somewhat an unavoidable issue for some plans because we've got annuity contracts that can't be transferred to another record keeper. We have annuity contracts owned by the participant, and there's just going to be issues there. So for, unfortunately, some of those are kind of a hurdle that are going to be challenging to overcome. It's more difficult to administer per participant fees a lot of times in a 403B plan. Some participants have annuities, some do not. And then a lot of times sponsors of 403B plans also have other retirement plans. They've got more than one. They might have a 401k plan as well. So some of these are unique to sponsors of 403B plans. And conveniently for you, we're about to kind of get into the exciting stuff of this presentation is that we've got some suggested solutions and how you might be working with your counsel or your vendors to get around some of those issues that are unique to 403B plans. And with that, I'm gonna pass it off to Craig.
Excellent. Thank you, Molly. And so what we're gonna try to do to the best of our ability, we're gonna sort of have some dialogue here among the three of us on these next kind of the rest of the presentation. I wanna just echo a couple of things which Molly said. First of all, what we're going to talk about, we realize and we see the list of attendees, and we have a lot of government employers and church-related employers, and then just exempt organizations. So we're going to talk generally about some ERISA stuff. We fully recognize that ERISA doesn't apply always to everyone. And some of these things we're going to talk about, but the core, the principles are the same, right? Even if ERISA doesn't apply, you're still going to be subject to same sort of state law fiduciary standards. So I think that's still going to be valuable and to everyone on this call. I also want to expand on this opportunity, and this is really our theme. you are now in the process of having to update your documents for some technical law changes. That sounds pretty easy. And what we sometimes see is sponsors will sort of, well, lots of times will rely on their vendors, right? Their vendors provide them with an adoption agreement. They explain it has to be restated for technical law changes. They stick it in front of the plan sponsor's nose. Sometimes they give it to us to review, sometimes they don't, and they sign it, okay? This is a great opportunity, and we're recommending that plan sponsors take a step back and think about that. And this is a good opportunity to think about potential ways to enhance your plan, change your plan, and that's the concepts and the ideas we want to raise here. The other point is these aren't perfect for everybody, right? And some of these will work, and some of them won't work, or maybe none of them will work. But these are ideas and thoughts that we've had. So we'll go through these. Again, these are all optional. The other thing that's important to remember is even if you have a pre-approved plan document, and sometimes those pre-approved plan documents, I frankly think they're sometimes more complex because they include everything, and you have to sometimes check a box. And so sometimes they're very difficult to use as compared to an individually designed plan, which can be drafted in a much simpler plain English format if done well. Even if you are using a vendor-provided pre-approved document, there is an opportunity. It's your plan, okay? So you can change that. You can deviate from the language in the pre-approved document, okay? So there's opportunities to do that. So be open-minded about that. So we'll go through these lists, and Jack and Molly, please expand, chime in, disagree, and hopefully we can make this somewhat, can have some dialogue going here. So the first one here, and I'll just go across the board, and then we'll go to the second row. This is something I have seen and recommended, and more frequently you see it in the 401k context. But as we all know, as Molly mentioned, there's fee litigation. And so one of the design issues, administrative issues is, look, negotiate, benchmark, negotiate with your record keeper, with your vendors, and really get those fees down to reasonable and as low as you can negotiate for. And then plan sponsors would pay for those fees outside the plan, okay? If you're not using plan assets to pay expenses, it's a mechanism, it's a way to sort of de-risk your exposure, okay? And Jack can comment on this and knows this as much as we do. That's not the common practice, right? The common practice is these are legitimate plan expenses. It is lawful to have those expenses paid by the plan. So it's perfectly legal to do so. But my argument is if you pay those outside the plan, and in the big scheme of things, if you look at the record keeping charges, for example, in comparison to the overall HR and compensation spend, they're minuscule, right? You'll spend that money on your employee parties and other internal team building stuff. So that's something to think about. That's a possibility. The second one that we want to talk about is we continue to see, and this is a very common mistake, is the definition of compensation in a retirement plan flows throughout the document, right? And particularly on a 403B where you have elected deferrals, you have a corresponding match or an employer contribution based on that definition of compensation. Sounds very easy, right? We go through, and the IRS has a safe harbor. They have a whole list of definitions. We can read those definitions, and we know what they mean, right? Because we know what all these technical code sections are referring to. But in practice, we know that the payroll systems, which are so complicated, and the pay codes do not always align with the plan document. And we'll talk to some clients that will have literally hundreds of pay codes. Now, I'm not sure why they have hundreds of pay codes, but they do. They have night shift, day shift, extra shift, holiday shift pay, just all kinds of pay, discretionary bonuses, discretionary one-offs, and such. So here's the point that we want to emphasize here is take a step back and look at your definition of compensation. I recommend, again, I don't think this is common, but my recommendation is to use a very simple definition of compensation, and use base salary or base wage. Okay, everybody knows what base salary is. Everybody knows what base wage is. Ignore overtime. Ignore all the special allocations and everything else. If you use a definition of base pay, and use that to calculate your elective deferrals, your match, and educate people, right? So if they want to, they may need to increase their deferral percentages, but that's a simplified way to simplify your plan and to potentially eliminate errors and corrections and all the stuff that we have to deal with. This next bullet here, the next tile, I guess, is, so this is a strategy that we've, one of the things that irks us is when somebody makes a election change and they go from contributing 6% to 8%, and there's a mistake and payroll doesn't implement it on a timely basis, or they just fail to implement it for whatever reason, and this goes on for years and crosses over tax years, and lo and behold, 2 years later, the employee comes and says, "Hey, I changed my election from 6 to 8, and you owe me a correction," right? And we have to go back and do some corrections. And if the employee comes forward right away, it could be fixed. It can be, there's ways to simplify that. So one of the things that we think you should do and think about doing is build into your document, into your legal document, an obligation that, and you need to communicate this in your SPDs and elsewhere, is that employees have an affirmative obligation to review their pay stubs. Okay, they don't do that, but you say you require that they do so, and you tell them in the document that they have a legal obligation to notify you within X number of days. There needs to be a reasonable period of time of any error, and if they don't notify you, then they're deemed to have elected whatever's going into the plan. Okay. So that's a strategy that we've used. We've used it with auditors, and we've used it as a way of really simplifying the administration. This next, and Jack and Molly, I've asked you to chime in, and I'm hogging on the oxygen here. This next tile, discretionary versus fixed match. Okay, again, I'll speed through a couple of these. This is another way to simplify and potentially eliminate errors and the opportunity to avoid correction. If you have a fixed match of 4% of elective deferrals, okay, and then technically, for whatever reason, you mess up the definition of compensation, you mess up the deferrals, and somebody doesn't get 4% of that compensation, you have an error. You have an error that has to be fixed, okay? But if I define it as a discretionary match, it can come out to 3.98%. Okay, and because it's discretionary, I don't have an error. Okay, and now just because I have a discretionary match doesn't mean, I can communicate that our goal is to put in a 4% match, and I can communicate that to employees. Now I also need to say that match is discretionary of the employer. But again, think about that, and by simply changing your match to a discretionary match, you can avoid some errors. Okay, this next slide here, there's also an opportunity, and again, this gets a little technical, but there's an opportunity inside your document to basically have different allocation groups. Okay, so I could say Division A is an allocation group, Division B is an allocation group, Division C is an allocation group. Okay, I can even take that further, and I can identify each person legally in the document. And this is sort of technical because you don't necessarily communicate this. Each person is their own allocation group. Each person is their own allocation group, okay? And again, by doing that, I can potentially minimize, if I do have a minor mistake, footfall with respect to a particular individual, there's opportunities for me to potentially avoid having to make corrective contributions. Another thing I want you all to think about is looking at your matching formulas. And this sort of ties into the vesting issue. I'm a fan of full vesting. I'm a fan of simplification. And if you're thoughtful about this, you can sort of have immediate vesting, and you know that you have to have immediate vesting for elective deferrals. You can have immediate vesting for matching contributions, but sort of accomplish the same objectives by potentially doing a tiered match, right? And a tiered match would work something like, we're going to contribute, these are all discretionary matches, and we're going to have a different rate of match for people with less than 1 year of service, and people with service between 1 and 5 years, and people with 5 to 9 years, and people 10 plus. So I have a tiered matching formula, okay? And so you may be 100% vested in a very low match or even a no match, okay? That's another simplified way to sort of get to the same point. You also avoid this forfeiture concept if you have full vesting. When you're, to Molly's point, again, we don't agree with the litigation, the forfeiture litigation that's out there. For years, we're very confident, what we've been doing, the way we've drafted our plans, and having some sort of discretion to apply forfeiture inside the plan document is a lawful way. It's been permitted by the IRS and Department of Labor forever. With that said, when you're now in the process of amending your plans, look at your forfeiture provision, and at its core, we think that one way to do it is to essentially eliminate discretion. So in other words, instead of creating an opportunity for the plan administrator to say, I can apply it this way or that way or that way, you're very concrete about the way that you're going to apply forfeitures. Forfeitures shall be applied first to reduce employer contributions. Okay, and maybe that's it. Period. Employers shall be used to reduce employer contributions. Period. Okay, you've eliminated any discretion and an allegation that the fiduciaries somehow have breached their obligations.
Craig, one thing I would say there is, I think you're right, making that a settler function versus blurring the line with any sort of fiduciary there. But a lot of plan sponsors now are also tracking forfeitures or any sort of plan level accounts, in their quarterly or annual plan reviews, just to account for any of those sort of assets. Again, kind of what the process is, but we have seen more ask in that area.
Yep, I agree with you, and the litigation has forced people to do that, right? For years, people sort of sleep at the wheel. These forfeiture accounts would build up, and you'd have hundreds of thousands of dollars in there, and they weren't applied. So yeah, I think vendors and consultants and lawyers are on top of that issue more. Again, this is a theme, so I won't get into the weeds, but we continue to see issues and the rules regarding crediting years of service, crediting vesting, crediting eligibility for to receive contributions. Hours of service is very complex. There's lots of errors made in that regard. Okay, and so there's what I'm suggesting, this idea of having immediate eligibility, tiered matching contributions, and then perhaps immediate eligibility and tiered matching contributions. You can get away from some of these issues with counting years of service, crediting rehires, vesting credit, sort of all that stuff goes away, and you can sort of design around that. Okay, so that's another opportunity and something to be mindful of and thoughtful of. Two more quick things, and then I'm going to segue over to our fiduciary discussion. This is another thing that in my practice and I think Molly's practice, we rarely see, but there's a unique feature for 403B plans that's pretty cool. Again, not widely used, but there's an ability to make contributions after someone has terminated employment for up to 5 years. Okay. And we have seen a lot of voluntary separation plans and phased retirement plans in the last couple of years. And there's a unique opportunity to build in this on a very tax efficient way, to build in those voluntary separation plans or phased retirement plans, whatever you want to call them, to use this opportunity, this 5-year opportunity. So basically you're putting your incentives in that plan, and it can be done in a very tax efficient way, and can also be consistent with sort of the purpose of the plan. So that's something to be mindful of and thoughtful of. So I'm going to segue to Jack here, and let me just do so. As we all know, there's a general trend to outsourcing, right? We're outsourcing many of our HR and benefit functions, and certainly we have all outsourced our record keeping for our retirement plans to a third-party vendor, and we outsource, and it's very common to outsource investment management on a defined benefit pension plan, except for very large or very sophisticated employers who might be in the business. Pension plans are almost universally professionally managed by outside vendors. And so as you're thinking about your plan, and again, this is not really plan design and legal stuff, but this is administrative and plan design, is think about your relationship with your third-party investment consultant, right? And these plans are unique because, again, they're all participant-directed plans. So participants are ultimately responsible for their own investment decisions, but we have to provide an investment menu, okay? And so Jack's going to talk about the different investment relationships that you can have with your consultant.
Thanks, Craig. And yeah, nice job. Sorry, didn't ask many questions here, but feel free to hit me on this side. But, the 321 versus 338 really refers to the fiduciary status of your advisor. And, first thing is, make sure your advisor is a fiduciary that holds themselves out, in a legal perspective as, operating in the best interest of your plan participants. And most do, but I would make sure number one is you're kind of evaluating your plan and your providers. Been doing this for a while, and if you were to ask me about 10 years ago, go ahead, Craig.
Just to be clear, when he's referring to 321 and 338, he's referring to 321 and 328 of ERISA, right? Which defines an investment consultant or investment manager, but that's 3 out of ERISA. That's what he's referring to.
Yeah, that's right. And, a lot of these 403B plans, when the litigation came out, 2008, when the plans fell under ERISA, I guess 2008, a lot of them didn't work with, professional advisors. And even 10 years ago, I would say, most plans engaged a consultant of the 321 co-fiduciary status, I would say. So an advisor in that capacity would, help, review the funds. Of course, fiduciaries are responsible for, the selection, monitoring, and replacement of investments. So, an advisor would come to meetings, preparing the due diligence, making recommendations, but ultimately any fund changes, the ultimate responsibility still lied with that investment committee, with that plan sponsor fiduciary. And that's kind of that 321 shared co-fiduciary. 10 years later, certainly the trend we're seeing is much more of the 338, call it discretionary manager, but that's really where the advisor kind of has the ultimate say and really takes on most of the risk and liability related to investment oversight. You all as plan sponsors, you have a lot of responsibilities. You may not be investment experts, and so maybe rely on that group to, again, perform the same due diligence, but instead of suggesting a recommendation, say, hey, we'd like to make this change in the large cap value space this quarter. And again, it's still I think the culture of not-for-profit, these 403B plans, is maybe a bit more parental than it is in the for-profit marketplace. So there's still maybe some dialogue, some communication back and forth. But the 338 is really where, the committee, the plan sponsor really hands over the keys to the advisor in really overall, overseeing the investments. Really the scope of work doesn't change for the advisor. The investment policy may say 338 rather than the 321, but the process, the risk factors, the performance factors, the qualitative factors, the deliverables, those don't really change. It just really shifts, really the responsibility, the risk and liability over to the advisor versus that shared responsibility as a 321. Importantly, as plan sponsors, and again, this is still referring to ERISA plans, you can't eliminate all of your, fiduciary responsibility in overseeing the investments. You can shift over, again, the selection, the monitoring, the replacement over to your advisor, but you still are responsible for selecting the advisor as a prudent steward for your plan. So you're still kind of on the hook for who you hire, for who you engage as your 338. So some people might tell you can eliminate it completely. It can't always be eliminated, but certainly, from a risk perspective, we do see a lot of plan sponsors, a lot of 403B institutions now engaging groups as a 338 versus a 321. A lot of times, again, the scope of service doesn't change. Even maybe the fee arrangement doesn't change. We've seen, some plan sponsors, they really want to focus in the committee meetings on, participant engagement and financial wellness or compliance. They want to, hey, tell us what we need to know from the investment side and maybe focus on some of these other factors, related to our plans. And so again, just kind of a consideration as you're evaluating your plan.
And Jack,
Molly did talk. Go ahead.
To the extent those fees are paid out, again, you need to benchmark and make sure you're paying appropriate fees. And to Jack's point, is sometimes, particularly larger plans, the fee may be the same, right? But to the extent you're paying those investment advisory fees, which is more common, I think, than paying the record keeping fees, paying those outside the plan, then you don't really sort of have an issue about overpaying. You don't have an ERISA fiduciary claim because you're not using plan assets to pay those fees.
That's right, Greg. And a lot of in the larger market, we work on a flat fee arrangement. Instead of some sort of asset-based fee where plan assets go up, it's a flat dollar amount that's just paid directly from the plan sponsor, and that just again, that keeps more money in participant retirement accounts. Just a couple of best practice considerations around investments. Then I'm going to talk about some hot topics related to investments, but again, 2016, some of the litigation around multiple record keepers, proprietary funds, too many funds, excess revenue share. It is a good time to kind of revisit your investment menu. Do you have the right number of funds? There's been a lot of record keeper consolidation, and there's less kind of proprietary requirements around the fund offering. We recommend separate your record keeper function from your investment management function, go full open architecture, offering a combination of actively managed funds and passively managed funds, kind of covering all the major, asset classes, but not offering too many. We've seen plan sponsors with multiple record keepers that just add choice. And there's over 100 funds in an investment menu. And that's just going to cause analysis paralysis. It's going to confuse participants. And then again, they either don't sign up for the plan or they're not aware of their investment elections. So, generally 10 to 15, kind of fund offerings within a plan is, maybe considered best practice. Counting those, target date investments as one. Take a look at your capital preservation offering. So capital preservation refers to kind of the cash equivalent fund in your plan. So money markets have been pretty popular the last couple of years with high interest rates. Maybe over the long term, maybe a stable value fund should be considered. A lot of times there's fixed accounts that may be affiliated with the record keeper. Maybe you can't offer those competing funds, but what is the capital preservation fund offering? What is the kind of cost associated with that? Is it affiliated with the record keeper? And just make sure you're kind of keeping the pulse on that. Target date funds, especially, those are the default funds in a lot of plans. Doing additional due diligence on those. Again, there's a lot of different offerings out there. There's actively managed, there's index. Now there's kind of hybrid target date managers where maybe they're indexing some of those efficient markets, but maybe active management, some of those, maybe lesser efficient fixed income and international. There's also now annuity options within some of these default funds that may be more kind of custom to your plan, where again, a participant could annuitize, part of their defined contribution plan upon retirement. That could be kind of an added benefit to that. And then again, we're talking about the core menu that's offered to participants, offering a self-directed brokerage, to some of those participants that may want to go outside, select individual securities. Again, that's where they kind of sign off saying, I'm outside of my employer's fiduciary responsibility, but self-directed is another option for some of those more knowledgeable investors. Just going to hit on a couple of things here real quick. A lot of your plans, may have moved from one provider to another. I talked about a lot of the consolidation that has gone on. There may be some legacy individual annuity contracts that are a part of your plan. Molly, Craig, speak up here. I think we'd have to look at your plan specifically to kind of understand the fiduciary responsibility. But, a lot of those cases, those legacy accounts can't really fall under the discretion of the investment committee. But still, it is a good idea to kind of track those investments, monitor those investments, even proactively kind of bring communication to your participants that may have, again, you don't want to do anything that's not in someone's best interest, but maybe educate them on, hey, now there's a mutual fund platform available that's institutional share class, that's open architecture. So again, those legacy accounts can add to maybe the complexity with your plan audit, or even just kind of tracking loans and distributions and things like that.
Yeah, a good example. Again, I agree 100% with Jack, and this is very common, and it's weird because you're like, how are these legacy accounts part of our plan? We don't even control them. These are just individual contracts, but there's really nothing we can do, right? We sort of put some self-serving stuff in our minutes to say we reviewed them, we recognize the account balances, and again, communication's the best. A good example is they might be in a kind of an S&P 500 type, or an all U.S. index type product, in one of these legacy accounts that's way more expensive than what they can get in the core offering. And so, again, it's a matter of doing your best to educate these people, and I think sending notices once a year, and that's sort of the best practice.
Just a couple of other things to hit on here. So collective investment trusts are similar to mutual funds. They're kind of regulated by they're banks versus kind of securities, and so they become really popular in the 401k marketplace because they're less expensive. Secure 2.0 actually opened the door to these being available in 403B plans, but the securities law hasn't changed. So they're not quite open to 403B plans yet, but certainly on the larger end of the market on the 401k side, you're getting access to a very similar type of an investment. T. Rowe Price, for example, would have a mutual fund version and a CIT version, but it's less expensive as a CIT. So look for those maybe in the coming years as securities law gets updated to kind of match up with Secure 2.0. But I think it was just a couple of weeks ago now, there was an executive order about alternative investments like private equity and cryptocurrency and private credit, being available to retirement plans. At this point, again, it's kind of the regulatory agencies are still reviewing this. Really only applies to 401k plans at the moment. Liquidity, I think, would be kind of a major factor here. And we've really only seen private equity maybe be part of a multi-asset type of an investment, maybe like a target date fund or a managed accounts. Again, so not open to 403bs yet, but is something that we're paying attention to. And then managed accounts. There was actually a plaintiff suit that came out a couple of days ago related to Empower and their managed accounts. So a lot of you may offer an opt-in managed account program, to your employees that maybe you want to kind of hand the keys over to an advisor or a record keeper to personally manage their account. You need to benchmark those fees and those providers, just like you're doing with your providers. So I know we're kind of 10 minutes left here. We talked about fee benchmarking a little bit earlier. The DOL term is reasonable. Your plan fees don't have to be the lowest. They just have to be reasonable. So again, benchmarking these on a periodic basis, understanding what your plan fees are. What are your record keeping costs? What are your advisory fees, your audit fees, your legal fees, your investment costs? Are you in the lowest cost share classes? And, utilize your consultants to benchmark the data using their internal data, external data. There's all sorts of software out there, RPAG, fiduciary decisions, and Schleck, lots of detailed reports. Craig, Molly, the DOL has never suggested, how often plans should maybe do a deeper dive, but we kind of say every 3 to 5 years, don't just check the box from a benchmarking perspective, but do some sort of an RFI, RFP, where you really go to market. And a lot of times, if you do that, you may just be able to negotiate lower costs with your current providers.
We agree.
And then just lastly, monitoring your service providers. The DOL now has put out cybersecurity guidance for plan sponsors. Are you reviewing, again, the SOC 1, the SOC 2, any kind of cyber procedures? What happens if, there is a participant hacked account? Craig talked about, all those plan design considerations. Do you work with a record keeper or a consultant that really understands your plan? Issues pop up from time to time with loans or things like that. Do you work with a group that understands what the document says, and on a day-to-day practices and procedures, is it a consistent practice? Do you work with a service team that is proactive? How is the Secure 2.0 rolled out? Do you like working with your parties? Are they informing you of kind of what's next best? So again, just kind of monitoring your providers. That's more of on the qualitative aspects. But there's been a lot of consolidation in the record keeper industry. Now I think we used to say there's 100 different record keepers out there. Maybe there's 50 now, but really it's more like 20 in our mind. Plans have grown. Hopefully your costs have shrunken as a result. But working with a provider, you can't really put a price on that. So I think that's right into my slides. Craig, any comments?
Yeah, I want to ask you a question here, and then I think I'll let Molly turn over to Molly. She has some closing matters to say here, but I want to ask you two questions. The landscape has changed in terms of the crypto and alternative investments, and you're right. I don't quite understand the liquidity, but as you and I talked about, there's so much money in the DC space that they're going to come up with a product they'll satisfy the liquidity hurdle for these participant-directed plans that are immediately distributable upon termination. But what is your personal general philosophy? I mean, I go to some of these committee meetings and it'll say, you'll get some demographics about participants in the plan, and it's like the average account balance is $38,000, right? And that's the average, right? And in my mind, I'm like, are you kidding me? Why would we be ever offering crypto or private equity when our average account balance is 38. These people are not sophisticated investors. It just seems like a bad idea to me. Now, the market will change, and I'll be wrong, right? Well, every 403B and 401k plan will offer these, but I guess what is your high level philosophy as an investment consultant? Do you think people with $38,000 or $50,000 or $100,000 account balances should be in private equity or crypto or real estate inside their core plan?
Yeah, I mean, and those are I can't make any blanket recommendations here. My compliance team is going to come after me, but certainly if we sat down with a participant, we'd want to look at their overall portfolio. Maybe they have a pension somewhere, or some other sort of income. Generally it's one or two people at an employer that are asking for Bitcoin in their retirement plan, and these are maybe more sophisticated investors. Maybe have a higher account balance. Again, it's not even really open to plans at the moment, and I think the first step would be maybe through like a brokerage window. I mean, if people think the S&P 500 is volatile, you should see the volatility with some of these kind of crypto products. Private equity would add even more complexity because of, again, the liquidity restriction. So they would have to put in some sort of an investment that, you remember, like the back end loads, back in the day, where if you wanted to pull your money out before maybe a 3-year term, you would give up a portion of it to have that liquidity provision. So for the rank and file $38,000 participant who's just trying to get the full match, or kind of get a budget on track, the target date investments, kind of just a personalized asset allocation to mutual funds or CITs that we've talked about. That's where we see 90% of new money kind of into plans, flowing. It's only, again, kind of a handful of people that are raising their hand asking for some of these more sophisticated products. And again, that may be an arrangement they would have outside of the plan. We're working with somebody. Yeah,
I'm not worried about our compliance. I think it's a bad idea. And I think if they have nobody has a pension plan, right? And if they have other assets, do your magic in your other accounts. That's my perspective. And again, the market will change, and when it catches up, I'll be wrong on that. My other question, real quick, Jack, we just got a minute. Is another thing is we know we have our core lineup. We know we have target date funds, and typically it's target date series is a QDIA. Many plans offer a brokerage window where someone can say, hey, I want to go to funds outside the core lineup. Okay. What is the advantage of offering a managed account? I believe, and I may be wrong here, is if I go to a brokerage window where I could do things outside the core lineup, essentially the record keeper in many ways is viewing me as a retail investor. Okay. And let me use Fidelity as example. If I open a brokerage account at Fidelity, so I can choose from a whole host of funds that aren't core lineup funds, I can engage through my brokerage account. I can do this managed portfolio offering. The plan sponsor has nothing to do with it. Why as a plan sponsor, what's the advantage of offering a managed account? Maybe getting a better price?
Yep. Yeah, I would say, if you're going through a window at Fidelity and you're working with like somebody from Edward Jones on your own, maybe you're paying 1.25%, for that help, and through a retirement plan. Again, the managed accounts, maybe they go outside the core menu, maybe they only work within the core menu, but it's 40, 50 basis points or 0.4 or 0.5% for that professional kind of personalized asset allocation. So I would say it's a higher touch service. They're factoring in more than just your age or risk tolerance. Certainly, you're going to have more flexibility with the brokerage window, but for some, we see it around maybe 10% of plan participants do like that managed account. They say, hey, I'm not an expert. Do this for me. If I pay a little bit more, I expect a little bit, greater return from my investments.
Okay, excellent. Molly, we'll turn it over to you.
All right. Well, that is the conclusion of our webinar. Thank you all for joining us today. We hope the information was helpful to you and your organization. As a reminder, this program has been approved for continuing legal education hours. To report your hours, click on the continuing education sign-in button at the top of the screen. A certificate of attendance, including your course number, will be emailed to you tomorrow, along with a recording of this webcast so you can listen to us on repeat. Be sure to complete our short survey. We do use your feedback for planning purposes, and also it dramatically affects our egos. So please fill out the survey. This concludes our webinar. Thank you all very much.
All right. Thanks, Molly.